Good day, everyone. I am Advocate Debra Vial. I'm employed at the Estate Agency, or what used to be the Estate Agency Affairs Board, and now the Property Practitioners Regulatory Authority, and I am the Acting Executive of Enforcement, Claims and Compliance. I'm here today to welcome you to CPD module on the Property Practitioners Act, an overview, and we'll be discussing the new Act and some of the important provisions. We'll look first at an historical overview of the old Act, and then we'll compare it and see how it's different to the PPA. As you know, the Estate Agents Affairs Board was created by the Estate Agent Affairs Act 112 of 1976, and it regulated only estate agents and business brokers. You will also know that it administered the Fidelity Fund, which is currently worth around 800 million rand. It also licensed estate agents and business brokers, managing agents, and particularly those who managed property in the share block and sectional title schemes developments. These were specifically included in the old EAA Act by a ministerial regulation. And of course, the Act and regulation prescribed education, licensing, code of conduct, audit, inspection, and enforcement parameters for the entire estate agent industry. There were some shortcomings in the old Act. First of all, transformation was not a criterion. The legislation was an apartheid-era piece of legislation, and it created barriers to transforming the estate agent industry. There was also limited scope in that the only regulating portion of the Act was for estate agents. So many property practitioner industries remained unregulated. It was also outdated and not inclusive of modern concepts of property ownership, business models, things like timeshare, fractional ownership, or technological advances in how we sell and how we deal with property. And of course, most practitioners in the industry at that stage were unregulated. So the legislation was not consumer-oriented. We didn't have the Consumer Protection Act at that stage, and it did not serve to promote a landscape of property ownership for all or provide for consumer education in the property industry, which is absolutely critical in an emerging economy. The other problem was that our inspection powers were declared unconstitutional and removed by the Constitutional Court. This was because the previous Act made some quite draconian provisions which related to inspection powers. It was declared unconstitutional, and so it fell into disuse. We were unable to enforce it, and that made compliance difficult in the industry. Let's move on then to the new Property Practitioners Act. PPA was signed into law on the 19th of September 2019, but as you know, it came into effect by way of announcement in the Gazette at the same time as the regulations on the 1st of February 2022. The fact that the regulations were gazetted at the same time as the commencement of the Act was problematic. It allowed for no phasing in period, and suddenly it existed overnight, and the EAAB became the PPRA and were required to implement it immediately. In terms of the new Act, a new regulator is created, which is the PPRA, or Property Practitioners Regulatory Authority. This takes the place of the EAB. It has enhanced regulatory scope and powers, and of course, the new name for the old Fidelity Fund is the Property Practitioners Fidelity Fund. A large component of property sector businesses and individuals who perform immovable property transactions or business broking transactions are now under the regulation of the PPRA. A few important changes to start off with. The regulator's mandate includes vast transformational powers and duties, one of which is the transformation of the entire property sector, which is of course very important. We have such things as the Transformation Fund created, a transformation research center, and those kinds of new introductions, which we are looking forward to implementing. Inspection powers have been restored and have been enhanced. Consumer education and protection is enhanced, and the conduct of all property practitioners is now regulated. This relates to compliance and enforcement. It also introduces mediation, dispute resolution. We've always had complaint investigation, and that continues, which is applicable to all property practitioners from the date of the 1st of February. Inspectors who conduct inspections for the regulator are also created, and the new implementation of a mandatory disclosure form for all property transactions has also been created. Let's move on to the definitions. Very important part of the Act because it defines who is regulated and who escapes regulation in terms of our legislation. We should note to start off with that property practitioners are defined in Section 1, and all property practitioners require two things to be able to operate lawfully. Firstly, a Fidelity Fund certificate, and secondly, a trust account, which is registered in terms of Section 54(1) of the Act. You'll remember that the old section under the old Act was Section 32(1). It's now Section 54(1). And remember that just as it was in terms of the old Act, property practitioners who are employees are not required to each hold their own trust account, but will use the firm who they employed with trust account. Also, it should be noted that certain exemptions have been provided for in the new Act. And exemptions from these requirements particularly may apply or may be granted by the authority. You will find them stipulated and the circumstances which relate to them in Section 4 and Regulations 2 and 41 of the regulations. Written exemptions with the conditions and the criteria will be issued by the PPRA unless the exemption is an automatic one, which does happen in limited circumstances, in which case it will be set out in a specific provision of the legislation. Section 1 of the definition property practitioner sets out some important requirements for all property practitioners to fall within the regulation of this Act. First of all, a property practitioner means any natural or juristic person. A juristic person, of course, is a person created by law, such as a closed corporation, a PTY company, or a trust. So we have a natural or juristic person who, for the acquisition of gain, it may be commission, it may be salary, any type of income, on his, her, or its own account or in partnership, in any manner holds himself, herself, or itself out as someone who performs a property practitioner activity. This is done directly or indirectly, and it is done on behalf of any other person. So those are the first criterion to qualify for regulation in terms of the Act. And these persons must perform certain specified activities relating to the disposal or management of immovable property or any business undertaking. And included in these activities, we have a whole long list of various provisions, and they include auctioning, purchasing, managing, selling, hiring, letting, advertising, exhibiting for sale, marketing, facilitating the sale or lease of, negotiating, canvassing, offering to canvass, whether by electronic or other means, collecting monies in respect of, or providing intermediary or facilitation services for any property practitioner activity or transaction. Second group of activities that fall within the auspices of property practitioner is one who provides, procures, facilitates, secures, or otherwise obtains or markets any financing for or in connection with the management, sale, lease, or otherwise of a property or a business. And this obviously includes a provider of bridging finance and a bond broker or bond originator, but it specifically excludes any person defined as a financial institution under the FSCA. So banks and credit providers are excluded. You will remember that the FSCA used to be the old Financial Services Board, and they are now the Financial Services Conduct Authority. So they regulate banks and credit providers in general. But those persons specified in the Act under this provision are included in our regulatory scope. Right, to continue then with our definition of property practitioner, we'll look at specific inclusions and exclusions. First of all, the exclusions. We see that anyone not performing property transaction facilitation activities in the ordinary course of business is excluded. So that means if you happen to be aware that the person who lives next door to you is selling their house, you have a friend who wants one very similar, and you get them together and you manage to assist your neighbor to sell his property. And he decides that in order to say thank you, he gives you an ex gratia amount of money. And that's something that you do apart from your normal job or your normal employment, then you are excluded from the Property Practitioners Act. Also, a natural person offering personal property for sale, an attorney or candidate attorney who is registered as such and performs property practitioners in the course of his practice, and also a sheriff as defined in Section 1A of the Sheriff's Act. So all of those are excluded from the provisions of the Act. All right, let's move to the inclusions. These are home ownership associations if they perform these property practitioner activities. Also advertisers or marketers of timeshare, fractional ownership, persons who manage any immovable property, trusts who perform any of these activities, and then remember directors, members, trustees, and employees of property practitioners if they perform or manage property practitioner activities, including attorneys' employees, are part of this group. So if they perform primarily property practitioner activities for the attorney or for their property practitioner employee. And then the last inclusion is anyone rendering any other service which is specified by the minister by way of regulation. So as she did under the old Act, she or he is able under the new Act to include any particular activity that relates to properties. Okay, the following activities have been specified as constituting property practitioner activities by the Minister in the Gazette. First of all, developers. This includes the sale by auction or otherwise by any person as part of an activity of operating a property development business. And this would include selling of property, selling any interest, right, or title in or to a property, or any property development that performs those functions. However, we have an exclusion, and that is that developers are excluded from the Act if they do not sell the properties or the interest in the properties themselves, but they subcontract that to a property practitioner who is properly licensed with a Fidelity Fund certificate. And in that instance only, the developer is excluded from the Act. The second ministerial specification by way of Gazette relates to business brokers and franchisors. And you'll see that all business brokers who market or transact in relation to any business undertakings are included in the Act. And this includes any activity that relates to small, micro, and medium enterprises, franchise businesses, or new startup ventures, including newly created franchise concepts. So there's some very wide words in this particular specification, and we will have to look and see how the courts interpret them. At the moment, we interpret them on their face value. They're fairly wide, and so they include anyone who performs any property practitioner transaction in relation to a business broker or franchisor business. We move on then to Fidelity Fund Certificates. Fidelity Fund Certificates under the new Act are issued for 3 years instead of 1 year. They no longer show the firms under which a practitioner is employed, although we are likely to put that in simply in parenthesis in order to identify the practitioner for members of the public. Business owner practitioners and juristic persons who are property practitioners have to hold and display their Fidelity Fund Certificate, as well as hold trust accounts unless they've been exempted. And no property practitioner may operate if he doesn't have a valid and current FFC. He cannot claim any commission or remuneration for any services rendered, and if he does so, that money is repayable, unless that person has a Fidelity Fund Certificate which was valid at the time of the transaction, and you'll find that in Section 48 of the Act. It also provides that conveyancers may not pay out commissions to property practitioners without receiving valid FFCs from the employer and the employee, and that's to be found in Section 56(5). So if you have an employee who conducted the transaction and the employee has a Fidelity Fund Certificate that is valid for the year, it is essential that the principal also has such a valid certificate. FFCs must be displayed at the place of business in terms of Section 47, and persons disqualified from being issued with Fidelity Fund Certificates are designated in Section 50. You'll remember the old Section 27, which excluded certain persons from operating as estate agents. We now have Section 50, which excludes certain persons from operating as property practitioners. And these include anyone with a criminal conviction which involves dishonesty, improper conduct, dismissal from a position of trust, anyone of unsound mind, an unrehabilitated insolvent, and any person guilty of discrimination. That's an interesting one and is of great value to us. You will remember the Vicky Momberg case. She was in fact an estate agent and she was found guilty of discrimination and was sentenced to imprisonment. During the time of her appeal, when this was pending, she was out on bail and she came to the EAAB at the time asking for a Fidelity Fund Certificate. Clearly, we didn't wish to issue her with one, and when we looked at the provisions of the regulations which allowed us to refuse a property practitioner, or rather in that instance an estate agent, an FFC, we found that discrimination was mentioned only in relation to the business activities of the person, which made it very difficult because Vicky Momberg's discriminatory conduct had nothing to do with her business. Fortunately, that has been remedied under the new Act, and any form of discrimination for which you have been found guilty disqualifies you from operating as a property practitioner. Another important aspect is that property practitioners are required to have tax and BEE certificates, but I should mention that there are certain automatic exemptions which apply in that regard, which we will look at shortly. Training compliance is essential, and anyone who has had a claim paid by the Fidelity Fund is also disqualified. So that's a circumstance where an estate agent has made off with some trust monies which belonged to a client, and failed to repay them at the time that he was supposed to. The client came to the board and the fund paid out an amount in order to reimburse the client for his loss. So if such a claim arose from the conduct of a property practitioner, that practitioner may not again operate as a property practitioner in South Africa. Property Practitioners Regulatory Authority also regulates industries and practitioners as indicated in the definition, and you will find that their industries are specified on the Fidelity Fund certificates. What is required for registration of each industry will be decided by the PPRA in consultation with each industry. So they will not be the same. You will not have the same requirements to register for as an estate agent as you would for something like a timeshare practitioner. In terms of Section 75(6), it should be noted that estate agent registration requirements remain the same as under the previous regulations until the industry and the PPRA have decided on other specifications and new regulations have been enacted in that regard. The regulations have in fact been enacted, and the process of deciding on new specifications for education is currently in process. The PPRA will regulate 12 industries defined as property practitioners in Section 1 of the Act. These are estate agents, auctioneers, bond and bridging finance originators, homeowners associations, and remember it's those who perform property practitioner activities, any property platforms, property facilitators and intermediaries, business brokers, timeshare and fractional ownership practitioners, payment processing agents, which is very important. We'll talk about that just in a few moments, attorneys, employees, developers, managing agents, and property practitioner platforms. Education, as indicated, currently the education standards for estate agents remain the same until they have been changed by the industry in consultation with the board or the authority, and a PDE is required for each and every industry to operate. So they will need to complete the PDE once that has been brought into effect. In the interim, we will grant exemptions where required in relation to education qualifications. Transformation, as I mentioned, is very important. That includes a transformation fund, property sector research center, and an exemption from a business audit for any entity with a turnover annually of less than 2.5 million. So the property sector transformation charter code must also be applied by property practitioners, and we must ensure that that is implemented. Briefly, to look at conduct, we have a code of conduct which is contained in the regulations, in Regulation 34. It's currently a hybrid code of conduct applying to all property practitioners, although there are large parts of it that apply to estate agents only. So we need to consult with industry and supplement it and add sufficient conduct rules to ensure that property practitioners operate ethically and professionally. The Code of Conduct includes conduct relating to mandates, confidentiality, integrity, trust monies, duties to disclose, and remuneration. Compliance and enforcement procedures for misconduct are also to be found in Section 24 to 30, and this includes the fact that we can send out inspectors with powers of inspection. We can also issue compliance notices, and then, of course, the mediation and adjudication processes where there has been misconduct are also available. We'll move on then to exemptions, which is very important, and you'll see that Section 4 of the Act provides that any person can apply for an exemption from any provision of the Act. We did not have such a provision under the old Act, and it made things very difficult where we had specific circumstances where such a provision should have been applied. Exemptions must be considered against specific criteria which are set out in the Act and regulations, and they are granted for a maximum of 3 years. We also have to provide all practitioners with a written outcome and reasons for the outcome of their application. Practitioners also have the right to ask for the matter to be reviewed by the minister if they are dissatisfied with the outcome. and exemptions can be amended, suspended, or withdrawn by the authority on good grounds. You will find that exemptions and all the nitty-gritty portions which relate specifically to how exemptions will affect you are dealt with in detail in a later module. We need to look quite clearly at trust accounts, and you will note here that all property practitioners can apply for an exemption under Section 4 from a trust account. The trust account exemptions are actually contained also in Regulation 2, and there we find that the legislator sets out the process which has to be followed where a property practitioner wishes to be exempted from holding a trust account. This is very important, and you will see that it can be done by way of an affidavit, which can simply be submitted to our audit department. The attachment of a confirmation from the auditor or accountant of the practitioner will suffice, and as long as the audit department manager is satisfied that the affidavit is compliant, an exemption can be issued in respect of a trust account. As I've said in the slide, you will note that there will also be a module specifically on trust accounts and auditing of trust accounts shortly. So in terms of Section 54, as a default position, all property practitioners must hold a trust account unless they are exempted, and they must place and keep all trust monies in that account unless lawfully entitled to pay them out. The regulations make provision for payment processing agents, which I mentioned earlier. These can be used by practitioners instead of holding their own trust account, and that's also on certain conditions. We regulate these payment processing agents who have to be registered with us, and they have to create a trust environment, and we'll talk about that more in the later module. Some very important provisions for us to take note of. First of all, the mandatory disclosure form, which is contained in Section 67 and Regulation 36, where a concept form is to be found. We have already had a great deal of feedback, much of it not positive, in relation to the disclosure form itself, what it contains, and what has been left out of it. So when we make recommendations to the Minister in relation to any changes to the regulations, we will certainly invite industry to give us their feelings and their views on the disclosure form and what changes should be made to it. However, in the interim, it should be remembered that this is a compulsory form, it's prescribed, and it has to be obtained by the property practitioner for every mandate which he accepts. Note, not for every agreement that he enters into or that he facilitates, but for every mandate that he accepts. The form relates to defects, inclusions, exclusions in respect of a property. It must be attached to every agreement, and it must be disclosed to all parties. Non-compliance with this mandatory disclosure form requirement creates liability against the property practitioner in favor of the consumer. So that's very important. Normally, your contract of sale, for example, is between your buyer and your seller, and any problem with the property requires your buyer to take action against the seller in order to recover his damages. Where there has been a failure to have a mandatory disclosure form, the property practitioner himself may well be liable for any loss which arises as a result. The consumer may elect to carry out his own inspection prior to the conclusion of the transaction. Quite obviously, if he wishes to engage his own inspector, a very prudent thing to do, and he has that right as well, specified in the Act. The form itself severely limits the value of any footstoots clause in a sale agreement. Now, you'll remember that in most sale agreements, there is a footstoots clause. And the footstoots clause has been watered down quite a lot in our law over the last few years. First of all, by the Property Practitioners, by the Consumer Protection Act, and secondly, in respect of the mandatory disclosure form. So you have to disclose certain defects and they must be reduced to writing. Property practitioners' rights and duties which affect the consumer. First of all, we have a cap on the Fidelity Fund claims, and any one claim may not be paid out to the value of more than 2 million rand. Also, the exclusion of claims is included arising from actions of property practitioners who have not been issued with a Fidelity Fund certificate. So the regulator has a huge responsibility here to ensure that consumers are aware that if they use a property practitioner who does not have a Fidelity Fund certificate, they run the risk of not being able to recover any monies lost as a result of the action of that practitioner. The advantages of using mortgage originators and bridging finance houses is also an important aspect of informing the public what these practitioners do and how they can assist them. Owners and property practitioners' rights in community schemes regarding the choice of property practitioners, their rights to trade, and undesirable practices are also contained in the Act. We had many community schemes who decided that only their own estate agents or property practitioners were allowed to operate within the area, and those kinds of provisions have been outlawed by the Act in prohibiting what is called undesirable business practices. There is also a partial amnesty provided in Regulation 41.41 for a limited time. And what that relates to is any practitioners, and of course it would be estate agents because no other practitioners were regulated, estate agents who operated unlawfully under the radar without Fidelity Fund certificates, who now want to become compliant, may come and register with the board, and if they do so within 6 months and they obtain their Fidelity Fund certificate within 12 months, then they will be exempted from being charged for misconduct for having practiced without a Fidelity Fund certificate previously. So that is a partial amnesty that applies to existing estate agents. And then we have the creation of a duty of care on the part of property practitioners to both parties. And this embodies the principle in the Code of Conduct, which requires that a property practitioner shall protect the interests of his client at all times to the best of his ability, with due regard to the interests of all other parties concerned. So the duty of care exists not just between property practitioner and client, but to all the world, as we phrase it in the legal world, regarding their business practices and activities. And of course, legal consequences for practitioners who fail to exercise their duty of care can be heavy. Thank you very much for listening. I trust that you will have a better idea of what the Property Practitioner Act entails and how it will affect you.